Welcome to Chapter 14 of Judicial Process, the Supreme Court, deciding what to decide. In this chapter, we'll address jurisdiction of the Supreme Court, doctrines of access, mobilizing the law to reach the Supreme Court, case selection, and the court's docket. The cases that the Supreme Court will hear is determined by the Constitution, federal statutes, and the decisions of the court. A small fraction of the court's cases arise under its original jurisdiction. That is, that a small number of cases can appeal directly to the Supreme Court without having to go through the trial and appellate court levels. Article 3 of the Constitution addresses cases that affect ambassadors, other public ministers, and consuls, and cases to which the state is a party. Original jurisdiction typically involves suits between two states. So, for instance, a boundary dispute between Texas and Louisiana. These cases can go directly to the Supreme Court. A very minor portion of the court's docket includes original jurisdiction cases. The court usually appoints a special master who hears the cases and makes a recommendation. Instead of original jurisdiction, most of the Supreme Court cases come from appellate jurisdiction. This is the basis for the vast majority of cases and may be altered by Congress. Since the Judiciary Act 1925, the court has mostly functioned as a court of discretionary appellate jurisdiction, choosing which cases it wants to hear, focusing on important issues of federal law. Cases come on appeal, writs of certiorari, and writs of certification. Appeals review lower court decisions that declared a state or federal law unconstitutional. Until 1988, appeals could be filed from adverse lower court decisions, and in 1988, Congress narrowed the mandatory appeals jurisdiction to those cases decided by 3-judge district courts, which is a small number on any given year. A writ of certiorari occurs when there is no requirement that the court accept a case for review, but the losing party in the lower court may request a discretionary review. Certiorari, which in Latin means to make sure, means that if the court grants certiorari, it is literally a request by the higher court that the lower court send up the record of the case. A writ of certification is when an appellate court, not the losing party, may submit a writ of certification requesting that justices clarify a point of federal law. Writs of certification are rarely used. Let's talk for a moment about doctrine of access, and in particular, justiciability. A justiciable case is one that is proper to be decided by a court. The court must have standards on which to decide the case and possess a remedy to correct the problem. Federal courts do not issue advisory opinions, an opinion issued to the legislative or executive branch about the legality of a proposed action. Instead, the courts view these as hypotheticals that do not follow the adversarial model. Standing. Standing refers to a person's right to bring or join a lawsuit and includes 3 elements. The case must involve an actual dispute, not a hypothetical one. The case must exhibit adversity, that is, that the parties in the case must have something to lose so as to present their case with vigor. And thirdly, the legal injury suffered must be direct. Generally, that means that the party suffering the injury must be doing the suing. What about taxpayer lawsuits? Can a citizen bring a taxpayer lawsuit challenging the way the government spends its money? Generally, the answer is no. The taxpayer does not have standing to bring that suit. How about class actions? Well, class actions require 4 prerequisites. First, too many people in a group to make naming them as individuals practical. Second, the class must be clearly recognizable. Third, representative parties' claims must be typical of the group. And fourth, representative party must fairly and adequately protect the interests of the class. Now let's think about ripeness and mootness. A case is ripe when the legal issues involved have evolved to a point that a clear decision can be reached. Generally, a law must be enforced before a lawsuit can be filed. Exhaustion of remedies requires a plaintiff to exhaust all possible solutions before coming to the court. A case is moot when the passage of time or a change in circumstances makes a remedy impossible. An attempt to prevent an action after the action has already occurred is moot. The Supreme Court does make exceptions to the mootness requirement, for example, allowing an abortion case to move forward even though the baby has already been born. What about political questions? Well, the justices of the Supreme Court refuse to decide cases they think should be resolved by other branches of government, labeling them political questions. There is no clear-cut definition that exists, and certain areas of law have once been deemed political, like reapportionment, only later to be heard by the Supreme Court. Political questions have been used to avoid wartime issues, for instance. Another area of the doctrine of access deals with political questions. Justices will refuse to decide cases that they think should be resolved by other branches of government, labeling them political questions as opposed to legal questions. Now, there's no clear-cut definition that exists, and certain areas of the law have once been deemed political, like reapportionment, only later to be heard by the court. Political questions have been used to avoid wartime issues, and this remains something of a gray area in the law. Cases arrive at the Supreme Court because of the work of many individuals and groups. Some of the parties go on to be celebrities, but most will just lend their name to a case. The parties involved include lawyers, interest groups, and the Solicitor General, who's the one who represents the government. Most lawyers who appear before the court do so regularly, referred to as the Supreme Court Bar. Oftentimes, these are former law clerks of the Supreme Court justices. Primarily, they counsel businesses on issues before the Supreme Court. Evidence suggests having an experienced Supreme Court lawyer makes you more likely to win your case. Interest groups also regularly bring cases to court and help develop legal arguments. They also participate by filing amicus curiae briefs or friend of the court briefs that provide information about a case and advocate a particular position. Interest group involvement has been steadily increasing in Supreme Court cases. Amicus briefs present the court with a wide range of perspectives. They are mentioned in a small number of opinions but believed to be influential in the court. High-profile interest groups who have been successful, like the NAACP or the Docket Fund or the Alliance Defending Freedom, get most of the attention, but many groups advocate and lose also. The Solicitor General is the spokesperson for the executive branch of government and an important player in determining which cases the court decides to hear. The Solicitor General's primary responsibility is to represent the executive branch when suing or being sued. The Solicitor General also provides the views of the government when the government is not a party to the case. The Solicitor General functions like a small, elite law firm. Half of the work involves coordinating and controlling appeals by the federal government when they are the losing party below, or responding to appeals when they won below but the case is appealed. The Solicitor General rejects many cases that could be appealed and wins often in the cases it pursues. The Solicitor General also files amicus curiae briefs stating the position of the government. They may file an amicus brief without the permission of the parties, or they may have a request from the court to file an amicus curiae brief. Solicitor General is a classic repeat player because of experienced legal staff and can influence the court's agenda. Each year, the Supreme Court of the United States has many more requests for appeal, somewhere over 8,000, than it can hear, which is usually less than 100. To make the review of petitions, the court uses a cert pool, which is a combined group of law clerks. The cert petition is randomly assigned to a law clerk who reads it and prepares a memo, 2 to 25 pages long, which is circulated to the justices. After reading that memo, the justices will vote on whether the court should grant certiorari. There is in the Supreme Court the rule of 4. This rule requires 4 justices out of the 9 to vote to grant certiorari. A denial of cert means the lower court decision stands. Not that the Supreme Court agrees with that lower court decision, because the court did not actually hear the case. Misreporting of cert decisions as agreement with a lower court decision is often common. What are the screening criteria that the court uses in case selection? Officially, court guidance in Rule 10 and the primary focus is on the presence of a federal question. But the court rarely explains when it does not grant certiorari, so it's difficult to predict what constitutes a substantial federal question. But researchers have made attempts to explain which cases will get chosen by the court for a full hearing. Table 14.1 shows Rule 10, Considerations Governing Review of Certiorari. Q theory hypothesizes that justices use a few cues to tell them when to grant certiorari. 5 cues in particular have been identified and studied. 1 is the federal government a petitioner. 2, conflicting interpretations of the law. 3, ideological preferences of the justices. 4, amicus curiae activity. And 5th, presence of certain specific legal issues. The court is more likely to grant certiorari in cases where the federal government is asking for the review. Between 50 to 70% of Solicitor General's requests are granted compared to less than 5% of other petitioners. Some argue that this is evidence the Solicitor General's legal competence is high, while others attribute the success to institutional deference. Conflict over the law can be found when an appellate court reverses a trial court, a dissenting opinion is written by an appellate judge, conflicting interpretations of the same law are had by different courts of appeals. Law clerks have reported looking for a conflict in the law as a predictor of certiorari, and researchers have deemed it one of the most important predictors at all. Case selection is related to the ideological preferences of the justices. Liberal justices favor hearing cases decided in a conservative direction in the lower court, and conservatives favor overturning liberal decisions. But justices must also think of the ideology of their colleagues, which might mean that a liberal conservative decision will stand on review. The court is more likely to grant review if amicus curiae activity is present. In one study, 36% of cases with more than one amicus brief were granted review. Amicus curiae briefs are relatively inexpensive to produce, and they help the justices pick those cases with the greatest potential for social, political, and economic significance. Some studies have also found that cases presenting certain issues are more likely to be granted review. Common issues include civil liberties, labor disputes, criminal cases, and questions of federalism. Not all studies support this finding, but the evidence makes sense given the freedom the justices have to pick and choose cases. The court's term officially begins each October and is referred to by the year in which it starts. For example, the 2015 term began in October 2015 and continues until 2016. Court eras are often referred to by their Chief Justice, so the Roberts Court began in 2005. Nearly 8,000 cases are filed in a typical year. Only 1 or 2 will involve original jurisdiction. Indigents may file in forma papyrus, which does not require a filing fee of $300. Case filings are resolved in 3 ways. The court can deny the petition, which leaves the lower court decision standing, and that's 99% of all cases. The court can accept the case, but decide it summarily without oral argument. These cases may be decided by a per curiam decision, typically short and unsigned opinions. Third, the court can accept the case for oral argument. The court uses its discretionary jurisdiction to shape the types of cases it hears. Historical periods appear to be linked with particular types of cases. The 1930s and 1940s, for instance, saw many economic, federalism, and regulatory cases. Cases today are more likely to present due process questions, civil liberty, or equality issues. The majority of the court's docket deals with the interpretation of federal statutes and administrative decisions. No cases were filed during the court's first 2 terms, and until the 1950s, caseload was rather modest. A regular increase happened after 1950, and in the 1980s, the number of petitions skyrocketed. Caseload growth at the court has not resulted in more full opinions. Most cases are rejected, and around 80 cases each year will be given full treatment. Some believe the court should hear more cases and give more opinions than they currently do. Table 14.1 shows the cases filed in the U.S. Supreme Court since 1950, and you can see the boom in the 1980s and in the 1990s. In conclusion, the court largely chooses which cases it will hear, which is its discretionary appellate jurisdiction. The court employs doctrines of access through its decisions to determine which cases are eligible for review. Lawyers, interest groups, and the Solicitor General are all key to the court's agenda. The court's docket is important and employs cues to help it decide which cases to hear year in and year out. In conclusion, over 8,000 cases are filed every year, but only around 80 will receive full consideration. That's a 1% acceptance rate and a 99% rejection rate. The court takes only the most important cases in any given term. Scholars have pointed to evidence which shows that the court's decisions about its docket are correlated with the ideology of its members, and deciding what to decide has important political implications in our republic.